Okay, well, we'll go ahead and get rolling, everybody. So today we're going to talk about the T&R form, termination and release. Two-part form. Anytime you are terminating a contract, you are going to use this. But first of all, the first order of business is before you terminate, unless it's just an obvious termination during due diligence, if you are in a struggle, if you have parties disagreeing about certain things, if there's some question about whether or not you have any doubt whatsoever that the deal could be rescued with some creative thinking, then obviously partner with your leadership team. The broker manager team here has approximately 85 years of experience to be able to help you to come up with creative solutions to every problem. And there are creative solutions to just about every problem that we can employ if everybody's on board. So first order of business is partner with us. There are two GAR forms for terminating a contract. And this is going to be true in just about everything. There's a unilateral, which means one-sided, one party has made the decision and has the ability to do it on their own. So it is a one-sided decision, or a mutual, which is both parties agree to transact and to terminate the transaction, okay? Anytime unilateral, there's going to be some disposition of the earnest money funds is going to be a part of that document. And anytime it's a mutual, there's going to be some discussion about who's getting commissions, okay? Because remember, unilateral usually means nobody's entitled to a commission, but mutual typically does have a commission involved, okay? So you're looking at the two forms, GAR form, which one is this one? I'm sorry.
So you can still use mutual under like a due diligence and stuff?
Mutual, you typically do not. You're getting ahead of me. Don't go there yet. Again, mutual is typically going to be when both parties agree at some point, and it's typically after due diligence. Yeah. Okay. So the unilateral has two parts. Notice the two blocks, and it's pretty simple. The one is the reason for the termination, and two is what is the disposition of the earnest money down at the bottom, okay? Quick question, when you terminate and you send this, the minute you send the email with this T&R, is it terminated at that point?
Yes.
Yes.
Okay, so it doesn't have to be received on the other end, correct? The minute you send it, it's gone, all right? Does that mean that if this is unsigned, that what happens to the earnest money? Let me rephrase that question. If this part is unsigned, can the earnest money be dispersed?
No.
That is the answer to the question. If there is not mutual signatures on both sides of this part down here at the release, then the holder of the earnest money is not going to be releasing that earnest money. He will then go through the normal process, 10-day letter, making the decision, let everybody state their cases and go, okay? But if there is not mutual signatures from buyer and seller on what to do with the earnest money, then the holder of the earnest money has no authority to do so until we have that, okay? So that is the unilateral. I always help, to me it always helps to see one that's actually been used and employed, and you're looking at one in front of you. So this one is the buyer using his right to terminate during due diligence. There's no other explanation that is necessary. But one of the other options that is available is the failure of following contingency on which the agreement is subject. So you could then use finance contingency, appraisal contingency, any of those up there if that is the reason. The following default under the agreement by either the buyer or the seller. So if one party clearly fails to do something, then that is a reason to terminate, okay? And if you look at, you know what, I didn't use it. I thought I had another sample in here, but one that was a failure to close. You do a termination like this the day after it was supposed to close when it didn't close. Okay, so if today is what, the 24th? If your closing date was supposed to be today, the 24th, and it didn't close for some reason, and they didn't extend, and they didn't do a unilateral extension or change the closing date, then tomorrow, you as one of the parties can send this termination to say, you failed to close yesterday. That is a default on the contract, and for that reason, we are legally terminating.
So I guess that's a race then, because they could also be sending the unilateral extension. So it's really who gets it first.
The next day they can't though.
But yeah, the next day, they really got nothing to stand on because they're the party that was the reason for the default.
True.
Yeah. Okay?
Got you, Rick.
It is also perfectly acceptable to use whatever the case may be. In this particular case, there is no disbursement. Earnest money had not been deposited yet. Okay, so it's perfectly acceptable to state what the reality of the situation is. If there was no earnest money that made it into deposit, sometimes if you written the contract for 3 days and they've changed their mind on day 1 or day 2, they're perfectly within their right.
I'll tell a lot of people that on the unilateral, you can start using, you can start like on contracts, you can put due diligence of like 4 days and have the earnest money due on 5, so that you don't waste time having them send the money in and then give them the check back.
Yep,
And a lot of agents will like be okay with that.
interesting. That's one way to do
I
it.
just do that.
Savvy agents won't.
Huh?
I said savvy agents won't. I've tried that a lot.
Oh, I do it on all of them.
Good agents are usually like, we're not letting you wait until due diligence is over to put your.
Oh, I told them, I'm like, well, I
I'll
usually
let
have a very
people
high
do it
amount, and I'm like, I always kind of play with them, I'm like, does it really make sense for them to deposit it and then get it back? Wouldn't you rather have them go through due diligence?
And I go, how much do you want this house?
Yeah.
Are your buyers?
With your client base, I can understand that, Guggen.
Money down.
With most, you're going to want to probably do it differently.
You give me $1 million, they're not giving it to me.
Well, I agree with that.
All
I
right.
just say the majority of mine like work through it. I guess you're a tough listing agent.
All right. So the other form that we can use is the mutual termination, and the mutual termination has the little additional section on there that says who's going to pay the brokers their commissions. Because remember, your buyer's brokerage agreement or your exclusive listing agreement has some criteria in it of when you are justified to be paid a commission. And a mutual termination, when everything else has been done, could be subject to commissions needing to be paid by somebody. So that's why you cover it there.
So what if you have a house and the seller just refuses to sell it? Do you still get the commission?
You can,
Okay.
depending upon the situation, using whatever legal document that you have, whether you're on the buyer side or the seller side, using whatever agreement that you have in place. It's generally not going to be a highly successful practice of suing your clients. That's why most brokerages don't do it. So,
You're saying they probably won't give you a referral later.
But
yeah.
if you represent the buyer, you can sue the seller for it.
Mm-hmm.
Yeah. It's
Oh, yeah.
legally-
Absolutely.
You brought them already willing and able buyer and they backed out the deal.
But ultimately, it's just a judgment too, right?
Yeah.
It's what?
Just a judgment.
It's a judgment. It's hard to get them to
Yeah,
pay.
they do, but it's not like, there's nothing legally is gonna happen to the person. They're not gonna go to jail. if they
Oh,
don't
I
follow
see
it.
what you're saying.
Yeah.
You know what I mean? That's
I mean-
what sucks, is you can do that, but it's not super strong even if you win. Spend
Really?
a lot
So
of
it's
money.
not like if they sell the house, they have to pay that commission out of it?
Mm-mm.
Oh, wow.
You get a judgment against them, but being able to collect on that judgment is a whole different story altogether. You're going to have a piece of paper from the court that says you're due this money, but getting that money into your account is a whole different story altogether. So, all right, and here's a perfect example of even a mutual sometimes may or may not have the commissions involved. I did a search. I asked Karen right before we came in here, I said, when was the last time you saw a mutual termination and release? And she said, very, very rarely. And I thought, let me do a search on mutual termination in my folders. And I actually found one. And unfortunately, the one that I found didn't have the commissions involved. So apparently we agreed upon a mutual termination, but agreed also to not collect commissions on it.
Is there, bless you, is there an example of something already in like a listing agreement where a mutual agreement will come up where a commission is paid out? Or does there have to be something like you have to have a buyer's brokerage agreement, or you have to, I was just wondering if language.
That is all going to be covered by either your buyer's brokerage agreement or your exclusive seller listing agreement. One of
But
those
you have
two.
to put something extra in the exclusive.
No,
So-
not for listing.
So what would be an example where the listing would still have to pay a commission on a mutual termination?
So if I had a situation like the husband and wife were divorcing, and they were like, they couldn't come up to a resolution on the house, so they said, we refuse to sell you the house. So Brett at that time told me that I could go to them and sue them for bringing them a buyer. We were one day away from closing, and they refused to sell me a house.
But you would have to sue them.
I mean, that's the only way.
That's the only way.
But legally in the document, you have the document that says, I brought you a ready, willing, and able buyer.
Yep.
And that's the judgment that you'll get.
Gotcha.
So you'll get the judgment like you're saying, but maybe not the money.
Yeah.
I think
I
either
wonder
way.
how hard that is, because as a seller, you could go, well, we didn't like that offer.
Well, then,
They were
you
just
can't- that's against the law too, is you can't resell it for another value, that's against the law. Like,
Oh, they went to resell it?
no, but you can't, what I'm saying is you can't do what you're saying.
No, I know, but like, you sue me saying, well, I brought you a reasonable offer, but by my definition, no, I wanted zero contingencies, period, so you didn't
But
bring
you
me.
accepted it.
Then it-
So
Yeah,
they
you
accept-
signed.
You accepted
I
it.
accept this as a ready.
So
willing,
then it's an
able
acceptable
buyer.
offer.
You
And they
accept
didn't have a reason other than we just don't wanna sell it.
it.
Yeah.
They were like,
Yeah, so what happened?
so, eventually the husband was like, he gave enough money to the wife to like, somehow they divided up their assets to like, he was able to claim the house and sell it.
But what happened with you though?
What do you mean?
Like, did you get the
Yeah,
commission?
He got his commission.
My buyers were threatening to sue them to say like we were gonna, like,
So they stayed in the deal?
yeah, my buyers absolutely want
okay.
the house. They were gonna sue them for breach of contract.
Yeah,
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 and then I was gonna tack on my commission on top of that.
Oh,
yeah.
Yeah.
What did it cost?
But just
Like the same day, it was just a little hassle of like back and forth.
Okay.
keep in mind, you are acting as an agent of the principal, which is the brokerage. You don't necessarily get to make choices about whether or not you're going to sue somebody or not. Ultimately, it's the brokerage that's going to make that decision for you. But we use a certain set of standards and criteria and knowing whether or not you're going to come up against something like this and win or not.
Sued like 4 people.
Yeah.
I have sued zero.
Shocking.
Okay, so TNR, 2 forms and 2 methods to be able to use it, unilateral or mutual, and you always have to consider 1, the reason for the termination, and 2, what's going to happen with the brokerages, with the brokerage commissions and the earnest money. Those are the 2 critical things. Okay, that's all I got for y'all. Let's go to work.